Bismillah. Assalamualaikum warahmatullahi wabarakatuh. Okay, brother, sister, I would like present my paper about between biological tests and legal barriers. This is evaluating Indonesian post MK-46 regime on inheritance right of children born outside marriage through the best interest principle. Hmm. Children born outside marriage in Indonesia continue to face significant challenges, including legal uncertainty, social stigma, limited access to inheritance right. Prior to Constitutional Court Decision number 46, 2010, such children had legal relationship or had just only legal relation with their mother and mother's family. So the MK-46 decision marked a turning point by allowing the recognition of a civil relationship between the child and the biological father through scientific proof, for example, by DNA test, for example. However, this normative shift has not yet resulted in comprehensive legal protection in practice. The central legal problem lies in the gap between biological recognition and legal protection. Although biological paternity might not be legally recognized, this recognition does not automatically refer inheritance right. Instead, inheritance remain constrained by formal legal status, paternal acknowledgement, and judicial correct discretion. The situation is further complicated by Indonesian legal pluralism, with combined civil law, Islamic law, customary law, resulting in uneven, inconsistent protection. Research gap. Previous studies have largely been descriptive or doctrinal, focusing on legality of MK-46 or normative debate among different legal systems. Very few studies have conducted in integrated evaluation of the interaction between biological recognition, formal legal barriers, and child protection principle. In particular, this has been no comprehensive evaluative model that place the best interest of child at the center of inheritance law analysis after MK-46. The study seek to fill that scholarly gap. Research question. We have three research questions. Does post MK-46 legal recognition of biological tests ensure effective inheritance right? And second, how do legal pluralism and judicial interpretation affect outcomes? And the last one, to what extent is the best interest of child principle applied in inheritance access? The theoretical framework of this research is grounded in the best principle, the best interest of the child principle, understood in three dimensions as substantive right of the child, as an interpretative legal principle, and as procedural rule guiding decision making. This principle is then examined within Indonesian plural inheritance system consisting of civil law, Islamic law, and then customary law to access coherence and substantive justice. So the methodology, this study employs a normative juridical approach complemented by doctrinal and comparative analysis. The primary data consists of Constitutional Court Decision number 46, 2010, inheritance-related legislation, and post-MK40 court decision from both civil and religious court. The analysis focus on social case outcome, but on judicial reasoning pattern, normative consistency, and orientation of child protection within the legal framework. And there is three key finding. First, about legal recognition. The finding indicate that MK46 has successfully expanded the civil recognition of children born outside marriage in relation to their biological father. This recognition open access to civil rights such as maintenance, identity, and potential inheritance claim. However, such recognition is conditional as inheritance rights do not rise automatically and remain depending on formal acknowledgement and judicial determination. And then second finding, this is about fragmented inheritance regime. The study revealed that the post-MK46 inheritance regime remained fragmented. Child born outside marriage often receive limited inheritance rights, such as reduced share, compulsory will, or no inheritance at all under certain customary norm. As a result, despite biological recognition, equality of inheritance right with legitimate children has not been achieved. And then our third finding, this is about legal pluralism. Legal pluralism is the major factor contributing to inconsistent protection. Court decisions vary significantly depending on whether civil law, Islamic law, or customary law is applied, as well as on the interpretative approach to individual judges. Consequently, cases with similar factual background may result in different legal outcomes, creating legal consistently for children born outside marriage. Best interest principle with missing core. Another key finding is the best interest of the child principle has not been systematically integrated into judicial reasoning. Many court decisions continue to prioritize parental marital status and legal formalities rather than substantive protection of child as a right-bearing subject. The principle often appear only as normative reference, not as core basis of judicial argumentation. The discussion highlight a structural duality within the post-MK46 regime. On the one hand, biological affiliation is increasingly recognized. On the other hand, formal legal barriers continue to restrict access to inheritance rights. This demonstrates that MK46 has primarily symbolic significance in expanding civil recognition without fully transforming substantive structure of inheritance law. The last our slide, conclusion. In this conclusion, while MK46 represents a progressive legal development, it has not yet produced a coherent, consistent, and equitable inheritance protection regime for children born outside marriage. Legal fragmentation relies on judicial discretion, and the weak integration of the best interest of child principle continue to undermine substantive justice. A shift from formalistic reasoning toward child-centered legal protection is therefore essential. And that's Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.